TorahCafe.com.
Let me ask you about billable hours. And again, I'm going to go for a metaphor that you all will despise. An interesting thing that came out of the discussions about healthcare reform, and I think this was first discussed by Atul Gawande in that New Yorker piece that if you all haven't read it, the president's read it, you all should read it. It really is great. And one of the things, he went to these two towns in Texas that had very similar populations, and one had like the most expensive medical care in Texas and one the least expensive, and he looked at the two towns because the health results were very, very similar, and he wanted to know, well, what's this town doing well and what's this town doing poorly? And one of the things he learned that apparently the single easiest way to cut down the costs of medicine is to switch from fee-for-service to salary. And the salary is the way they practice medicine at the Mayo Clinic. And their costs are unbelievably low, and the quality of care is very, very high. And if we know that to be true about medicine, is that a good model for law? That is maybe the billable hours model, something that now has run its course?
I can just say that the thing I miss least, having gone into academia, is billing hours. It's very difficult, and I think it's very difficult to do it honestly. To be candid, I always try to err on the side of not billing as much, just because most firms, or a lot of firms now, bill by the 10th of an hour, which is every 6 minutes. And the notion that you could actually accurately keep track of every 6 minutes of your day is very difficult. And as I say, my solution to that was to cut it back a little bit, just to make sure I was being square. But I think it's more comfortable to work on a contingency where you get paid based on the result, or on a fee-for-service, but it's a hard thing for, especially the larger the firm becomes, it's a harder thing to account for economically.
But say a bit more about the ethical aspects of this, because there must be all sorts of conflicts where serving your client is your predominant obligation, but you have obligations to your firm, and the tendency to keep a case going, or the temptation to do more work. It seems a bit akin to ordering unnecessary tests on a doctor's behalf, and you can always tell yourself, well, it's better to know more, it's better to do more.
Well, I think everybody hears the stories about lawyers who who'll bill 20 hours in a day or something like that, and you just think it's impossible. On the other hand, if you're a worrier like I am, and you wake up in the middle of the night and spend 4 hours worrying about a case, do you bill that? I never did. But you could. You're working on the case. So
yeah, and you're meant to be thinking about the case a lot, even when you're not formally.
Absolutely.
Now I will start thinking, okay, now I'll stop thinking. It doesn't work like that, does it?
It sits in the back of your mind, and you're working on the problem if it's a difficult issue, and sometimes it comes to you in the middle of the night, what the solution is. But certainly, it's fraught with ethical problems, but I think any system of charging probably would be.
Do you prepare your students to deal with this?
I don't know the answer to that, to be honest with you. I mean, we do teach professional responsibility, and this is a component of it, but if the question is, do they come out knowing exactly how they're supposed to function, I don't know the answer to that.
That's probably where that whole experience of mentoring comes in. How does the first job teach you? Who are you surrounded by? Where do you go? And it's probably something people don't really tell you how to do. You sort of like figure it out, and that's really, I think that's a very good example. That's where what's in your gut in terms of your ethics comes out in terms of your practice, because there really is nowhere to go other than the 0.1 issue, the every 6 minutes. And then again, I bring in the clients. They're not sitting still for billing that is, in their eyes, outrageous, which could be to the lawyer's eyes perfectly accurate.
I answer questions of Jewish law to many people who are deep adherents to Jewish law because of my role in a rabbinical court. And the hardest questions I get from lawyers, and I probably get one a week from a lawyer, involves billing problems. Because it's really, overbilling is theft. theft is sort of a big no-no in the Jewish tradition. In other traditions as well, but in the Jewish tradition, theft is a big no-no. And, it's important to recognize that unlike other areas where, so to speak, frequently the other side of an ethical concern is God, and you can hope that God is forgiving. The other side of an ethical concern with billing is the client who you're stealing from. And concerned people come all the time with ethical problems relating to billing. You shouldn't think, though, that if you move away from billable hours, that you solve these problems either, because when you do flat billing, you encounter the same, different set of ethical problems. Like, I have two clients who have come in with the exact same matter. And I want to flat bill them both. I'll do the job once, hand it to both of them, and charge them both a fine fee. In fact, not doing the work twice at all. All billing matters, all professions that entail handing somebody a bill, which is almost all professions, require that a person who hands you a bill ethically examine themselves to make sure that the bill is fair. But let me tell you what's part of a basic measure of fairness. A basic measure of fairness is how you explain the process to the client up front. This is why it's so important to tell people that they bear a duty to explain to the client what is the rules. It doesn't matter whether the firm rule is you bill for travel time or you don't bill for travel time, so long as the client is told, here's the rule. When we travel to you, we bill you for the travel time, and then we work on another client's matter while we're traveling, and we bill that client too. That's how you get lawyers who bill 30 hours in a day. They travel 2 6-hour flights. They bill in those 2 6-hour flights a total of 24 hours, and then they work in between on a client matter. It's not hard to bill 30, 35 hours that way. And if the retainer agreement with the client says, I recognize that when you're traveling to my office in California, you'll bill me for the time on the plane, and you can work for another client while on the plane and bill that client too, then everybody's agreed. The problems are when billing practices are secretive and not well discussed, then the client feels that they've been hoodwinked, and sometimes they have.
Rabbi, do you think that that is hoodwinking? The client who sponsored the trip is charged by the lawyer for all the hours, and at the same time, other clients who got the work done on the plane get billable hours. Do you think that's hoodwinking the first client?
I think that if you're going to bill two clients for your time simultaneously, both clients have to be told that that's a possibility and agree. I believe that the general rule of client billing is absent a special agreement to the contrary. If I bill you for 6 hours, I don't bill anybody else for the exact same 6 hours. That seems like a reasonable presumption. I recognize that you can have a contrary agreement, but when I turn to you and say I'm going to bill you for 6 hours of my time, it's because I'm not simultaneously going to bill somebody else for those 6 hours of the time. And most normal people on the street, when they encounter a lawyer who's billed 30 hours in a 24-hour period, inherently say, oh, well, that's cheating. And I think the reason why the typical ethical person would say that is because it is. You can get permission from both clients to do that. That's not a problem. But if you don't get permission, when I'm billing you for my time, I'm not working for anybody else simultaneously.
Rabbi, I disagree with you because the rule requires, RPC 1.5, both New York and New Jersey, requires that the ultimate bill be fair and reasonable. So while you may put it in the agreement, that doesn't necessarily mean it's ethical or consistent with the rules of ethics. But because the ultimate bill, if you're billing those people for the work, it may not be fair and reasonable. So it may not comport with RPC 1.5. So just because you put something in agreement, in retainer with a client, doesn't mean it complies with the rules of ethics.
But I think it is inherently ethical in the normal sense that we use the word, which is if I turn to a client and say, I'm traveling to your office in California, it will take 4 hours, I will bill you for those 4 hours, but while I am flying to you in California and billing you for those 4 hours, I will be working on another client matter and bill that client too, and the first client says it's okay, then it's okay.
I have to disagree too on slightly different grounds. That what you're saying is, from my perspective, transparency is a necessary but insufficient condition. That yes, of course, you have to be transparent, but what I think we can often be too loose with the use of agreed with or consented to. That a lawyer is very sophisticated about his own or her own profession. The client less so. And so there are questions of equity beyond people. I'll agree to anything. You're talking fast. You seem like a lovely man. That if there's an hour and you're doing work for two people, well, then you have to cut that fee in half. That there are only 24 hours in a day, and you can't bill 30 hours. Even if the client sort of says, "Oh yeah, while you're in the plane, yeah, do whatever you want, read the magazine." It's not fair.
So I would agree with you if the client is unsophisticated. I don't know that that's true when you're working at when the client is Goldman Sachs and the lawyers.
They did great the last few years, I hear.
I'm not going there now.
I'll tell you one story that's slightly irrelevant, but because I think you'll like it, about this kind of how this opportunity to do this kind of, in my opinion, double billing or billing the same people for the same hour. We have opportunities in my field too. That I used to work at the Letterman show, and the talent department, the people that book the guests, had expense accounts. And one of the things they could expense is if they took a potential guest out to dinner, they could put in for that. And there was there were 6 bookers in the office, and there was a day as the records were being reviewed that on the same day, all 6 of them filed dinner with Elaine Boozler. It was wonderful. It was amazing. She was like going from table to table, apparently. Fat as a house.